Hey guys, let's talk about secret evidence. Was my thumbnail clickbait? No, there is secret evidence in the Manson cases. Two of them, at least, right now. This could spread to the other cases, and it could spread in terms of scope in the cases that already exist. So secret things that you can't know about. You can't see it, you can't listen to it, you can't even know really what it's about. And it could be important to the case. So how does that work? I thought people had a right to know what was going on in a trial, that this was supposed to be public. So let's look at how evidence can be made secret and how the courts deal with the competing interest of the public's right to know what's going on in judicial proceedings and the right of the parties to keep critical information secret that could damage them or harm them or be harassing or something like that, things that deserve to be private as much as they can be. How does that work? So in the Ninth Circuit, which is where these cases are occurring at the federal level, they recognize the common law right to public access to judicial proceedings and records, and also a First Amendment right. So, hey, that's pretty clear, right? People need to be able to see what's going on in court. And that's true, and we'll talk about how that works. So that's the right of the public and the press to know things that are going on in court, including the evidence that supports court decisions. Now, that can go up against the right of people to say, look, this is intensely private. I don't want to let this out there. This would really harm me. Or here's a technical trade secret that if the other side sees it or it gets out in public, it'll destroy my business. So there are mechanisms to balance that. So what's gone on in the Bianco case is a protective order has been entered that allows the parties to designate information as confidential, which keeps it secret between them for purposes of the case. That similar order has been entered in the Jane Doe case in the state court of California, and they're both kind of very similar. So we'll start with the Bianco case. So to frame this in your mind, how this First Amendment right of access and common law right works, the trial, obviously, that's the centerpiece. That's where the public really should be able to know what's going on, because we shouldn't, at least, or used to not, want to have secret trials, right? That's not in the concept of open government. That's not in the concept of keeping government in check. This should be public. A court shouldn't be able to do things in secret. People should be able to see what's going on. What are you ashamed of? And that would increase confidence in the judicial system, and I think it's certainly true. So the trial is the centerpiece of that. Just under that would be what's called dispositive motions. In other words, a motion that, as an example, could decide the entire case. Say a summary judgment motion where a party presents evidence to say, there is no possibility that a jury could have any question about this because the evidence is so clear either for or against that there's not a factual issue to be determined at trial, so this should just stop right now. So a dispositive motion is kind of almost like a trial, especially if it ends the case, right? That's it. So the court stops somebody's case. Well, wouldn't we be as curious about that as we would seeing the evidence if it went to a jury? So that's the level right under that. Then you get into motions that are just people arguing about dates, like, hey, this person needs to come to this deposition. Hey, they didn't answer my question all the way. Hey, we're having an argument about this, judge. That kind of thing. Doesn't decide an issue in the case. It's just the parties bickering as they move their way toward the trial. Then the lowest of the things in that is what's called discovery. And it's called discovery because the parties are trying to discover information, evidence that will support their case or harm the other side's case. So that's depositions, exchange of documents, things like that. That's not inherently secret. It can be public, but it's at the lowest level of interest because it's not a judicial record. It doesn't even normally get filed in court unless it's part of some other paper or something like that. Now let's apply that stream there of the highest level of concern: trial, dispositive motion, regular motions, and then discovery. Let's apply that to what's going on in these cases. So in the Bianco case, the parties actually, Bianco herself and Manson, agreed to a protective order, and then the court enters the order. The court doesn't have to, and the parties can reach an agreement that they don't seek to make an order. But it's fairly typical that this occurs in a situation where somebody wants something confidential, that the parties will agree to the terms of it. Then they'll ask the court to enter that as an order. And of course, an order, it makes it more serious to violate for the parties, because then they can be held in contempt. Something could be done to them rather than a mere contract between them to hold information confidential. So that happened in the Bianco case. What that means is when they turn information over to each other, if they feel like it's something that should be private, not exposed to the public, they can designate it in a certain way under the order as confidential. Then the party receiving it, emphasis on the word party, the party receiving it then has certain obligations they have to keep that information confidential. There's a certain limited amount of people that they can show this information to that's authorized to receive it from them. So that helps contain that. If they want to show it to somebody else, that person may have to execute an agreement to become part or to become under the jurisdiction of the order, that sort of thing. There's various mechanisms that if it gets accidentally exposed, how they're going to handle that. So generally it provides that we can proceed with this litigation, and if you give me something confidential, you don't have to worry about it going out into the public. What if it gets abused? What if the person's like, well, I'll just make everything confidential. I don't want anything out there. So if they're doing that, the order is typically contained, and the Bianco case does, so does the Doe case, contains a provision that allows the party who's receiving the information, who thinks it's being overly designated, to go to court and say, Judge, this stuff is not confidential in any way. It's being abused by the other side, and they could have that confidential designation struck. This can matter because let's say you want to talk to other people about it, third-party witnesses and things like that, and it gets a little bit more tough to do it if it's confidential information because you may not be able to show that information. And that's going on in the Doe case, for example, where Manson wants to present information to third parties that identify Doe as the plaintiff in the case in certain situations, and she doesn't want that identifying characteristic to be allowed. Okay, so they're having an argument over that. And Manson's point is pretty obvious that, the context of the case is she's suing me. I need to be able to question these people in the full context of what's going on. And she objects to it because she's saying I'm confidential who I am. And if you do that, even if these people are subject to the order and they not necessarily going to agree to be subject to the order, this information is much more likely to get out. And I'm offering a compromise that will allow you to do what you want to do. And they're trying to work that out. So that's what happens. So this information gets designated as confidential. Now that's between the parties and the people who are subject to the order, which is just the parties, and the people who become subject to the order is not everybody on the planet. And then what happens? What if they want to use this information before trial as they're moving through the case and it's already occurring to some degree in some of this motions practice that's going on? Then they can ask the court to file it under seal. Okay, so Judge, I need to tell you something about what's going on in this discovery dispute or something like that, but the other side has made it confidential, or I think it is confidential, and so I want to file this portion of it, or depending on the circumstance, maybe all of it, under seal. That's a little different. You can't just do that. The court has to give you permission for that. So in theory, when they grant a protective order, the things that are made confidential are for good cause. The parties have to show the court, look, here's why this stuff really should be confidential, Judge. This meets the criteria for things that can be confidential at this stage. And if you want to keep it confidential, say at the trial, things change. And because remember, there's this highest level of interest at the trial, and then it moves down. Well, when you're at the trial, the court has to have a compelling reason to keep things secret. Whereas down at the discovery phase, it just has to be good cause to have this protective order. So it kind of increases. And in the middle there are people wanting to file things under seal. But it's very typical that the court, if both parties are agreeing to it, are going to let them put things under seal during the early parts of the case. That way confidential information doesn't get out there. They're not going to have but so much of an argument over that. And that's occurring in the Bianco case, where some things are being filed under seal, or like this motion to compel Ashley Walters, part of it is redacted and the rest of it is under seal. So some of it is there for the public to see, but some of it is not. And part of the action in this motion to compel Ashley Walters is she's saying, hey, I've got private information, and if I respond to this subpoena as a third-party witness, some of my private information would get revealed. And Manson's people are saying, listen, we already have a protective order in place in the Bianco case, and you can take the protections of that and apply it to the information that you would like to designate confidential. And that's a very strong argument. He should win that one, I think. I don't know what information she has that's confidential, so there could be something that could change my mind, or the judge's mind, which is the only mind that's important in this, if it comes to that level of fight. Who knows? But generally, that's a solid argument that there is a court protective order in place. So the way the cases are postured right now, there's a good chance that the Manson versus Wood-Gore case after the December ruling goes up on appeal, and that's all that's going to happen to it for quite a long time, right? If it goes up on appeal, nothing fast is going to happen. Think about the appeal in the Depp versus Heard case. They haven't even gotten to where they're going to brief the arguments yet. And then after they do that, then there's an oral argument, and then eventually, finally, at some point in the distant future, the court would rule on it. So that could be the same fate for the Manson versus Woodgore case, so that could slow down. The Walters case is on appeal, and Smithline, we don't know if she's going to continue her case or going to abandon it. But let's say for a moment she abandons it and the court ends up dismissing it. That leaves you with Bianco and the Doe case, and those are under protective order. So it could be the case that as people watch these, there's going to be critical information maybe coming from the accusers or critical information coming from Manson in either case that could really seriously help or hurt either side that you won't know about because it's going to be filed under seal. So that's going to limit the quality of factual analysis in these cases, at least until they move into a dispositive situation where the case is being actually decided and the court is going to have to require or do an analysis of a more compelling reasons to keep things secret, and it may narrow the scope of what is secret in the case. So that means, for some of the documents that get turned over, and by document, it's pretty much any kind of written communication. It could be a text message, email, a letter somebody wrote, who knows, right? Or videos or depositions, that portions or all of those things could be designated confidential, and then you're not going to see them. Now, remember, in a case of a deposition, you're generally not going to see it anyway, but there really was kind of no rule against one party leaking it out if they wanted to, or attaching it as an exhibit to a motion, and it would become part of the judicial proceeding, and you would see it that way. So there was a good chance to see those things, but on the other hand, if it gets designated confidential, it's not going to happen, because if it goes, they're not going to be able to leak it. And then if it gets attached to a court motion, at least early in the case, it is probably going to be filed under seal, and you won't be able to see that either. So that information that's designated confidential, unless one side decides to contest it early on, will not be viewed by the public until the case reaches a higher level, when the court takes a greater interest in protecting the public's right to know what's going on and why the court would be making its decisions and having an open trial. Then those things become more important, and maybe some of the information would come out at that point. And maybe at that point, that's when parties would start to argue about, Judge, this can't be confidential because it really isn't, or whatever. That's, you don't want to file a motion every day, every time somebody designates something confidential, so you might just hang on to that for a while. So there's secret evidence in the case, and only the parties know about it. It's not that, say, for example, one side presents to the other some confidential information, doesn't mean that the other party can't see it. So if Manson gives over something, say, to Jane Doe that he thinks is confidential, it doesn't mean that she can't see it. A confidentiality order can be two levels, and that's how we used to do it in intellectual property cases. And that would be, say, for example, confidential, which means you can't leak it out into the public. And sometimes you have a restricted or confidential attorney's eyes only. So that if something were like that, and I don't think the protective orders even have that in these for this type of case, but if it were, then let's say Manson turned over something that was super terrible, but for some reason couldn't even be seen by the other party, then you would restrict that to their attorney's eyes only. They couldn't even show it to their client. That's typically something that's in a technical case, like an invention or a secret process or something like that, where competitors are litigating against each other. So a core aspect of the secret that it has to be turned over to the other side, but even the lawyers cannot even show it to their client. Now, I know you're thinking, well, but they'll just show it to them anyway, but they typically don't. I certainly was in a case a long time ago in the Middle District of North Carolina where we were taking a deposition of the other party, and we wanted to show him a document. His attorney had mistakenly thought that it was restricted confidential, was something he couldn't discuss with his client, so he hadn't prepped him on it. And so he refused to let him answer because he was just sure that if he could get his copy of that document, it would say restricted confidential on it instead of just confidential, but it didn't. So he wouldn't let the guy answer. So we ended up adjourning the deposition and going to court, and the court ordered that attorney to personally pay the legal fees involved in all this, including preparing for and setting for the next deposition to answer questions on this and the court reporter's fees. So the court would take it very seriously if you violate a confidentiality order or if you use it as an excuse to stop discovery in an inappropriate way. So that was a technical case. That was a scientific case. So that, I can understand why you wouldn't want the person to answer on things that he thought he should have been able to prep him on, or that we were trying to trick him on that was actually restricted confidential, but that wasn't the case. So it's a serious issue, but in this situation, I think the parties are all going to know about each other. It's just they're not supposed to be, pumping stuff out into the public or filing things publicly that are previously designated confidential. So you see a lot of these applications in a federal case that we want this under seal and that sort of thing. So that's how secret evidence works. It can be really secret earlier in the case, and then it becomes harder to keep it secret as a public right to know starts to get stronger. A lot of times cases settle before, that really gets that far anyway. And we'll just have to see in this case. And then finally, if there is a trial, the court should look at each thing and say, well, this is really confidential or really isn't, that sort of thing, and be less of it perhaps at that point. Just keep it in mind that for these cases, there are things probably being traded back and forth between the parties at this point in those two active cases that you're not going to know about. So it could be something devastating for Manson. It could be something great for Manson. It could be something devastating for Bianco or great for Bianco. And we just might not see it. We might not have any idea how that could be playing into the minds of the parties and their attorneys on whether they should settle, how they should proceed in the case. So it's a new limit on what we can know in the universe of things that we can't know. But I thought I would explain at least what protective orders are and what they mean and how they get used and how they flow through a case. Well, that's it. Thanks.